One thing I've seen a lot is that when people get a judgment against them, they think they're going to be real tricky and they're going to give all of their property to their brother or a friend or someone they know or their mom or sell it for almost nothing. This is generally what's called a fraudulent transfer. Basically, if you have a judgment against you or you know there's going to be a judgment against you, you'll try to give all your money away or hide it or structure it in such a way that whoever you owe money to isn't going to be able to get it. And there's a lot of things you can do regarding asset protection, but for the most part, you have to do all of those things before you get sued or before you know you're going to get sued or before you get a judgment against you. Generally speaking, if you're dealing with someone that's aggressive and going after you and or has an attorney or has gotten a receiver appointed that does a good job and does what they're supposed to do, enforcing the court's orders, there's not too much you can do after the fact, certainly not like you can do before the fact.
Now we're talking about the transfer of assets. And the question of what an asset is sometimes be important. Obviously, money, real property, that's obviously an asset. But some things people often don't think about with assets, particularly if you're dealing with a company or a corporation or a business, are things like a phone number, specific client information, business lists, trade secrets, a website. These are all things that are assets of an individual or a company and should be included. There are some very specific things that are excluded. The definition of what's an asset is tremendously broad, but there are some things that are excluded, things that are encumbered by a valid lien, up to the extent of that lien. So if somebody has a lien on, say, a house, for example, a mortgage, and you transfer it, you don't necessarily get, the mortgager doesn't lose their interest in it. Now, the thing is, the question has to be a valid lien. And a lot of times people try to play games, try to, create some other company, give them a lien against their company. So they say, all this property, it's not encumbered by, you can't get it, there's a lien. And the rule is, it's pretty clear, it's not just a lien, it's a valid lien. Also any exempt property, generally speaking, under bankruptcy code. If it's exempt for terms of bankruptcy, it's probably going to be something that you're not able to get at or that you're allowed to transfer. The theory being, well, if the person kept it, it's not like the debtor would be able to get it anyway. So also another example that's very similar is the homestead. Particularly in Texas, there are some very strong homestead exemptions. For the most part, if you have a house, nobody's going to be able to get it. Now, in other states, it's not nearly as far. Sometimes it's up to a certain amount. So depending on where they have their property.
The Texas Uniform Fraudulent Transfer Act allows you to not only go after the person you have a judgment against, but also go after and actually sue whoever they're transferring their property or assets to. In the Texas Uniform Fraudulent Transfer Act, there are 11 what are called badges of fraud that are specifically written into the statute in order to help a jury or a judge determine whether or not a particular transfer is fraudulent. Now, it's important to note that these aren't the only ones, but these are specific ones that are actually in the statute, and so they're going to carry an awful lot of weight with courts, and generally speaking, it's been my experience that they are the 11 that the courts are going to look at. The first one is whether or not the transfer obligation was to an insider. A question of who is or is not an insider is a very specific question. Some obvious people like relatives or some other people like people that you have a business relationship with or have a certain percentage of ownership of particular entities are by law insiders. Something else that is looked at is whether or not the debtor retained possession or control of the property after the transfer. A good example of this is, I gave my property or the house that I live in to my mom, but I've still been living there for the past 2 years. So that's something that any court's going to look at. Also, the question is whether or not it's concealed. If somebody openly does something, if somebody or some entity enters into some sort of a business relationship with another entity and announces it, everybody knows what's going on, that's not a badge of fraud. But if it's done quietly, quickly, suddenly, if it's one particular entity that transfers it to another entity and they have a similar name, that's something else that the court's going to look at. Also, whether or not the debtor had been sued or threatened with suit before the transfer of the obligation was incurred. It's important to remember, it's not just the lawsuit, it's been threatened with suit, and a lot of the court cases that have come recently have indicated that if the person has reason to believe that they're going to be sued, then that is sufficient. Also, another badge of fraud potentially is whether or not the transfer is substantially all of the debtor's assets. If a debtor sells a truck that may or may not be under market value, that's going to be viewed a lot differently than if the debtor literally gives everything that they own to either a person, people, or particular entities that they know or control. Whether or not the debtor absconded, whether or not they left, whether or not they just sort of disappeared, figuring, well, everything's been gone somewhere else, so I guess I don't have to worry about anything. Whether the debtor was insolvent or became insolvent shortly after the debt was incurred is another badge of fraud that the courts and judges and juries are going to look at in order to determine whether or not a transfer was fraudulent. Whether or not the transfer occurred shortly before or shortly after a substantial debt was incurred. For example, you enter into a business deal, take $500,000 from someone, and then immediately say, well, we're out of money, sorry. That's another factor that the courts, judges, and juries are going to look at. Also, whether or not the debtor transferred the essential assets of the business to a lien holder, who then transferred the assets to an insider of the debtor. Kind of send it over there, send it back. Very common, very typical scheme you see a lot. Another thing that's important to keep in mind is in relation to the piercing of the corporate veil, which basically means holding one entity liable for the debts of another. If actual fraud is found, and there's another way to prove it under constructive fraud, which can be a little bit more complicated, a little bit more statutory, kind of the analysis can be a little bit more difficult. But if it's actual fraud, then that is by Texas law sufficient to pierce the corporate veil, which has become increasingly difficult in Texas and is probably one of the toughest states to pierce the corporate veil in.